Welcome to Behind the Case podcast, a podcast that focuses on navigating the challenges our clients face with divorce and family law in Dallas, Fort Worth, Texas. Behind the Case is brought to you by the Turner Monahan legal team. With over 70 years of collective experience in divorce and family law. Together, Tyler Monahan, Keaton Monahan, Tina Campbell, and the Turner Monahan team will discuss real-life cases, answer questions, and explore family law areas from divorce to child custody. Our goal is to clarify scenarios and demystify legal jargon, making the process less daunting and reminding you that you're not alone. So sit back and let's discuss what happens behind the case.
How does stress and anxiety impact decision-making during divorce case?
I think with individuals, the stress and anxiety colors anyone's decision in any aspect of their life. In divorce circumstances, obviously they're going through such a traumatic moment. I mean, we always talk about our clients are some of the best people going through some of the worst moments of their life. And so because of the anxiety and the stress involved with it, people are very sometimes short-sighted in their decisions. They want to make decisions for right this minute, wherein we are often as the attorneys looking at a larger perspective, the longevity of something. And so sometimes it's very hard to get our clients to not be so focused on today as opposed to down the road in that kind of a thing.
Yeah, I agree. And I also think that when you're going through such an emotional process with your finances, your property, your children, it is natural to respond to these circumstances with your emotions and not logically and thinking what the law and what says and what the court would say in those situations, because you are naturally going to respond in fear or you're upset about the divorce. So whatever those emotions are, and it's your finances, that's your future. So I think that we often have to remind the clients that you're emotional, and that's quite fine for you to be emotional and express those feelings with me. But it's my job as your attorney to look at things at the big picture and look at things the way the judge would look at them, or opposing counsel is going to look at the situation, and kind of bring them back to let them vent, let them have that emotional process, but also to remind them that I'm here to be the logical legal side and to bring them back into focus and what would be a better result for them in the divorce or the custody matter.
And I think when individuals hire counsel that have experience, one of our tasks is to help educate them on what is, what isn't, what's possible, what's not, the law, how the judge will look at things, so that hopefully that reduces some of their anxiety and stress, because a lot of it is just the sheer unknown of what's going to happen with their kids, their assets. They've heard about their buddy's divorce, their friend's divorce. They've watched other family members, and it may not have gone well. And so all of that fear is just constantly playing around. Hopefully our advice and our explanations of things can help reduce some of that, which then can make the process a little easier on our clients. That's at least our goal.
Right. I agree.
Clients are very emotional. It could be because they're dealing with some kind of physical and emotional abuse. So how do we prove, or how does proving the physical abuse affect court proceedings?
Well, and depending on what the court proceeding is, if it's a protective order proceeding, which sometimes does occur during a divorce, we need evidence. I mean, just the client's testimony oftentimes is not enough. Just because you said it happened doesn't necessarily mean we can prove to the court that it did happen. So that's on the protective order side. So police reports, witnesses, other witnesses would be good. Pictures of the abuse, things
Hospital
like
records.
hospital records. All of those things are great for the protective order side. But in conjunction with the protective order, the divorce is also happening, or oftentimes happening at the same time. And the abused spouse may then be entitled to additional support from the abusing spouse. And oftentimes, if children are involved, then the abused spouse then also has an advantage for custody of the children. and possibly increase child support depending on what the possession schedule looks like, because the abused spouse then will have grounds for sole managing conservatorship and having all of the legal rights to the children rather than sharing them with the spouse. And so it can have a great deal of financial impact on the result of the divorce, as well as the custody portion of the divorce.
Mm-hmm. And sometimes it is somewhat difficult to prove if there hasn't been any type of documentation that was collected over time or in the most recent incidents. So that is something we would certainly advise, any potential clients, is make sure that if these circumstances are occurring, try to get some type of documentation so that it's not a he said versus she said type situation, that we have something definitive that we can show to a court, so there is no question and we can get the best possible protection for them.
You mentioned different ways that you can prove physical abuse, but how do you do that for mental abuse?
That's pretty hard. If the spouse that's claiming abuse has been in therapy for an extended period of time and can testify as to how the abuse has affected that spouse, that's one way. It's really hard to prove. Would you agree?
Absolutely. I do think it would certainly require the involvement of a mental health professional without question, to show, or even testimony potentially from third parties who have witnessed a dramatic change in the demeanor of that individual over time during that relationship, those kinds of things. I don't think it would be sufficient evidence for just the individual to say, I'm a victim of mental abuse, without there being something else. Because unfortunately, there are many cases where people are untruthful about these types of things and simply make these claims in order to attempt to get an advantage in the divorce, because there can certainly be financial advantages and also advantages in regards to custody. So the court, though they're very sympathetic to these types of events, they need something with which they can kind of hang their hat on as far as making these determinations.
Yeah, I would agree. I think the mental and emotional abuse as a whole, there's probably fewer than what people think, the true long-term emotional and mental abuse, because as the marriage deteriorates towards the end and people try to hang on, oftentimes we have clients that will come to us for a divorce and reconcile, but then often come back a year later. And during that time period, there's a lot of mean words that are probably said on both sides, and maybe more so from one side than the other. And that is, while it is emotional abuse, it's more just, I'd say, I want to call it normal fighting in the deterioration of a marriage, but it's probably not going to be considered true intentional mental abuse from a court's view.
You kind of mentioned, I know we talked earlier, Heather, as well, that, the court doesn't like you just saying these things out here. So how does the court handle where one spouse is accusing the other of abuse without evidence, or they're falsely accusing them for those gains? How's the court handle that?
Let's take a quick pause here. If you or someone you know is navigating divorce or family law matters in the Dallas-Fort Worth area, reach out to Turner Monahan for a free legal consultation. Call us at 817-332-4477 or visit us at tumolaw.com. That's TUMOLAW.com for a free legal consultation. Now, let's get back to behind the case.
If one spouse is claiming or calling the other spouse a narcissist, that's very common in a divorce. It's a claim that is the courts hear all the time. The courts do not like that claim. There is a particular judge that will absolutely not even hear you or fine you for using that term unless you are a mental health professional and can diagnose that disorder. Because the true narcissist is, while many clients and potential clients feel that that is who their spouse is or has been, they are not qualified to make that diagnosis. Then the other one is, often the male spouse will claim that the wife is bipolar. That is another one that the courts are going to turn their ears off. They're not going to hear the rest of your claims because you're deflecting all the fault of the marriage on the other party because, again, you are not a mental health professional and that you have self-diagnosed your spouse as bipolar. That is something that I don't recommend you use in a term in a divorce at all, especially in a court proceeding. But maybe take a step back and really look at the big picture, because while they may change their mind on a flip of a dime, they're not necessarily, that doesn't make them bipolar. I mean, I think it's clear that the marriage has deteriorated and it's time to separate at that point.
Yeah, and I think people have gotten very accustomed to throwing bipolar, gaslighting, narcissism, all those things as just regular adjectives that people have started using in just normal conversation. What people need to recognize is those are actually medical terms of art that have a definition, that have a formal diagnosis. And so when you start just describing your spouse in that way to a judge, Heather's absolutely correct. They completely ignore those things. If there has been a medical diagnosis that actually shows those things, okay, that's a whole different ballgame. And the court will take that very seriously and make appropriate orders. Otherwise, it just sounds like you're trying to, again, manipulate the system to get an advantage on something when you don't have the foundation for it. So you have to be very careful about that because, again, our judges are human. They make determinations based on who they believe is being more truthful.
Right.
And who is, bringing all the information to light. So it's never a good idea to say, I'm perfect and they're horrible, because we all know that's not true. And that makes a court very reluctant to then believe the information that you're providing to them. So you have to remember that what you're presenting is a full picture of yourself. And you want to make sure that it's clear to the court what's really going on and that you're not trying to manipulate them.
How do these kind of allegations affect child custody while going through a divorce?
I think very much the same. If there's a medical diagnosis, then the court's going to want to make sure that the parent with the diagnosis is taking their prescribed medication, seeing their therapist on a regular basis in order so that they can show that they are capable of giving their children their needs and to be safe with their children. But if there is no medical diagnosis and these claims are made, I think, again, the court's not going to consider much of what that parent is saying in the rest of their testimony, because if you're just trying to manipulate the judge and manipulate your case to put yourself in a better light, that's something that judges hear every day, and they're over it. And so our job as attorneys is try to what is our argument? What is your concern? And try to really kind of figure out not necessarily the narcissist term or the bipolar term, but help them put their concerns in words and in a format that the court will listen to and hopefully respond to in their favor.
And understand that having a mental health diagnosis does not automatically mean that the court's going to prohibit you from having any contact with your kiddos. Because we've had lots of cases where individuals were reluctant to seek any kind of mental health assistance because they thought it would prohibit them from being able to move forward and have a meaningful relationship. Well, in reality, if you do have a condition and you need treatment, that will put you in a better position to have a stronger relationship with your children because you're able to acknowledge it and be healthy and to move forward and take the right steps. So we also want to make sure our clients understand that the court wants you to get the care and these treatments that you do need. And so, one, the courts don't want you to lie about what exists. And two, they don't want you to pretend that things don't exist if they really do. It's a matter of being truthful and forthcoming. And that is important, particularly with us. It is impossible for us to provide adequate representation if our clients are not being truthful and forthcoming with us so that we can provide them the best possible advice, because we've probably seen it.
Yes.
We've probably dealt with it in the past, and we can help move people forward, but they have to be brave enough to discuss it with us.
What is the first step somebody going through, maybe they're in the abuse situation, they're being abused? What should they do? Because I know there can be fear around that, even because, if the court's going, oh, you're going to just claim this stuff, we're not going to believe it. So what should that person do that is on the other side getting abused mentally or physically? How should they handle the first steps in a divorce?
Documentation. I mean, and we say that probably 20 times every day to each client. Document, document, document. Bring me the pictures. Bring me names of witnesses that have seen the verbal abuse or the physical abuse, people who have seen your bruises, your medical records. Give me the evidence we need so that we can determine what evidence is best that we're going to be put before the court. You can't document too much. Like, give us everything you have, and we will determine what is useful to put before the court in your argument as to show that there was abuse, whether it be emotional, physical, or mental abuse.
And I think one of the first steps that Heather and I take with clients who have these types of issues is figuring out the plan.
Yes.
What is your plan going to be once we file the divorce? Because just having a conversation with us is fine. But once that divorce is filed and that other party has been served, if there are these issues, we need to make sure that once that person gets served, you're in a protected situation so that you know you're safe until we can get into a temporary orders hearing or into a protective order hearing or whatever the next step is. So we very often talk to our clients about, do you have financial resources? Do you know the passwords to the bank accounts? Is there money that you can move so that you know you'll be able to survive for that next couple of weeks? Is there a place you can go and hang out? Can you and the kids go out of town for the weekend while we're getting him served so that he can have the opportunity to calm down just a little bit? So thinking kind of proactively, what is my plan, is also very, very helpful. And being able to have knowledge of your financial resources and things like that so that you do know that you can move forward and take care of yourselves until we can get the court to intervene, which is very helpful.
Absolutely.
And then just the last question to wrap it up is, I know we keep talking, when the judge sees this. So whenever you're going through divorce, if you're in an abuse situation, is it almost a guarantee you're going to a final trial, or are there other mediations and ways to get out of it?
Most cases, I would say, do not go to a final trial. They are negotiated for settlement, either just between attorneys or at mediation. So, and both ways are less adversarial ways to finalize your divorce rather than having to go to trial and put everything out in front of the judge again and kind of relive those abusive situations. So it's much better to usually negotiate a settlement or mediate a final settlement. And if there is a protective order in place, there are ways to have a mediation without the parties being in the same building. Since COVID, Zoom is a beautiful way to do mediations now, and we use them all the time. And we can mediate virtually. We can mediate at the courthouse where there are deputies there every floor. And so there's safety that's put in place, whether it's, especially in a physical abusive situation.
Mm-hmm. I mean, absolutely. We can certainly move forward with negotiating and reaching a settlement, even if there are these allegations. We just want to make sure, of course, that if there are these allegations of abuse, that our client doesn't feel as if they are being manipulated or they are being forced into any kind of agreement. So that's why we do take every step we possibly can to make sure that the environment is as safe as it can be, so that they can make decisions independent of any kind of fear that they have.
Thank you for joining us on today's episode of Behind the Case. If this episode offered insight or helped clarify some aspect of divorce and family law, we encourage you to subscribe and share it with others who might benefit. For those in the DFW area that are in need of a legal consultation, you can reach us at tumolaw.com. That's TUMOLAW.com or 817-332-4477 to schedule a free legal consultation. Remember, the journey through legal matters can be complex, but you don't have to navigate it alone. Until our next discussion, take care. Please note that the information provided in this podcast is for educational purposes only and is not intended as legal advice. Listening to this podcast or contacting our team does not constitute an attorney-client relationship. For advice on your specific situation, please consult with a licensed attorney in your area.